Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we are going to talk about another type of scam, and I'm going to give you some suggestions about how you might avoid problems when you purchase real estate. So stay tuned, and we'll get down to that down at the beach. So I was telling my wife the other day that I had done a video on scams and scammers, and that it had been fairly well received by you all. And again, I'm grateful for that. And she said, well, you really ought to tell them about how I got scammed. And she told me that she had seen recently that there was a chain of RV parks who charged a flat upfront lifetime membership fee of, I think she said, $7,000. Now, I haven't researched that. She may be wrong. I don't know. But the bottom line is that if you paid the $7,000 fee, well, you could stay at any one of their parks absolutely for free for thereafter. And she said, that reminded me of when I got ripped off by the health club. And in her case, what happened was she became a life member of a health club in a small town, and that lasted approximately 6 months before the business went into bankruptcy and closed, and the money that she spent on that life membership was worth nothing. So I want to talk a little bit about things like life memberships and explain to you why I think they are bad and why in many cases they may actually be scams. Now, there is a business organization called a limited liability company. And a limited liability company allows someone to set up themselves in a limited liability situation where they can operate and do business as XYZ LLC. And if they wind up not having any money to pay someone who sues them, well, that's just the way it goes. They take it into bankruptcy. The debts are discharged in bankruptcy, and that's tough luck for the people who are owed money. So one of the ways that I have seen this done, and it happens to be legal in most respects, although if there is fraudulent intent, I suppose you could make a claim against the individuals that set these up, but where a couple of people get together, Smith and Jones get together and they set up LLC number one. And LLC number one buys a building, and they buy all of the equipment to set up a health club: treadmills, bikes, Nautilus machines, free weights. Pretty hefty investment, maybe in the nature of $300,000-$400,000. And when you add in the building, another 100 or 150 on top of that. So you've got a really huge investment. And that entity owns the building, but it doesn't operate the health club. So now, instead of Smith and Jones, you have Jones and Doe, and Jones and Doe form LLC number two. LLC number two begins to operate the Fresh Start Health Club. They employ all of the people, and they set up all the bank accounts, and they agree to lease from LLC number one all of the equipment and the space to carry out the business of operating a health club. And then they immediately go out and they start offering life memberships to everybody in town. You pay $2,000 and you are a member for life. You never have to pay another dime. You can come use the treadmills and the bikes and the weights and everything else whenever you want. So people flock to the place in droves, and part of the deal between LLC 1 and the LLC 2 is that they will pay a portion, usually it's a very large portion, of any life memberships over to LLC1, because LLC1 is the one that invested in all of the hardware. So, if they collect $500,000 in the first 6 months, $400,000 of that gets paid over to the LLC number one, as in for rent and for whatever is owed on the lifetime memberships. And then, because they're just bad managers or whatever, or because the memberships fall off, they can't sell any more life memberships, and they go bankrupt. Well, what happens? It's only Jones and Doe here, who own the LLC, that go into bankruptcy. LLC number one doesn't go into bankruptcy. So the building and all of the assets, they can't be reached in bankruptcy. As a result, the only thing that can be reached is whatever is left in the account of the LLC. Now, Jones and Doe, whatever their capital investment was in the LLC, that's gone. But can the creditors come back and try and go after them personally? Not unless they can prove a scheme and an intent to defraud. And if they can do that, well, then they might have something to worry about. But even then, it's an uphill battle, because that's a case that's going to wind up being tried in the bankruptcy court. A funny thing about bankruptcy courts is you don't get a jury. The only thing you get in bankruptcy court is a judge. And if the judge doesn't like the fraud case or doesn't believe that it is, that it's been proved, you lose. And although you can appeal, in most cases, appeals are relatively unsuccessful in bankruptcy. So you have to be really, really careful about buying a life membership in anything, because the instant that LLC or that company or that corporation goes into Chapter 11 bankruptcy, that life membership goes right out the door. It becomes a debt of the estate. And if it goes into Chapter 11, for example, if it's a corporation instead of an LLC, and it goes into Chapter 11 and says it wants to reorganize its debts, well, if it does that, then the trustee in bankruptcy can avoid the contract. So you enter into a contract for life membership with the company. The trustee can avoid that contract. He can basically nullify it and say, I breached your contract, tough luck. And the person whose contract has been breached has a cause of action, which he can try in bankruptcy court against the corporation. But even if he tries his case and wins it completely, he is only going to get the amount of money that the first in line creditors, the people who have secured debts, for example, people who have loaned money and who have a security interest in equipment, buildings, that sort of thing, they're going to get paid first, and they're going to get paid in full. The people who are unsecured creditors are not going to be paid in full, in most cases in bankruptcy, because if they could be paid in full, there'd be no reason to go into bankruptcy. So for that reason, you want to avoid buying a life membership in pretty much anything, simply because there is no guarantee you're going to keep that life membership. Which brings me to my next issue. A lot of people, for their first time home purchase, will purchase a home by contract for deed. A contract for deed is essentially an agreement where you go in and you say, I am going to pay you $300,000 for this property. I'm going to do it over 15 years, and I'm going to make monthly payments of, X number of dollars to pay you. And when I have paid you the full $300,000, then you are going to execute the deed and give it over to me. Well, again, the bankruptcy courts present a huge problem for this issue. And that bankruptcy court issue is this. Sometimes people who own real estate don't own it free and clear, but they can still enter into a contract to deed to sell it to you. So the first thing you should do for anyone who is offering to sell you property as a contract for deed is check to see if they have clear title to it. Check to see if they own the deed or if there is a first deed of trust that names a mortgage company or a bank as the actual owner of the property. And even assuming that that's the case, that they do have free and clear title to the property, then at the very least, you should also do a credit check to make sure that they have good credit at the time you go into it, and you should check periodically over the course of the loan. Now, what I would recommend is if that's the only way you can buy a house because you're a first-time buyer and you don't have a lot of credit built up, that's fine. But as soon as you have 1 or 2 years of payments under your belt on that property, go convert it into a conventional loan and pay it off. Because if you do not do that, up until the week before you make the final payment, they can take that into bankruptcy and you can lose your investment. And the only thing you are going to get back is some amount of money, hopefully, but there's no guarantee of that. And you're not going to get the property, even though you will have paid for it, 99%. Here are 2 instances where what you don't know about the laws of bankruptcy can really hurt you. And most of us don't ever have reason to know about the laws of bankruptcy because we're financially solvent, and we presume that the people we deal with are financially solvent. I am absolutely certain that everyone who dealt with Alex Murdaugh thought that he was financially solvent, when in fact, he clearly was not financially solvent. So, for that reason, you have to be very careful about contracts for deed and life memberships in any kind of project like a health club or investment club, anything like that. That's what I have for you today. If you have any questions, please leave them in the comments down below. Like, share, subscribe. If you have the opportunity today, do something nice for someone. It'll make your day. Have a terrific day, folks, and I'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.